So here's a question. What happens when the lawyer you hire knows that you're guilty of the crime that you're charged with? And does that matter? I think it's a question a lot of people wonder, and I've done a lot of meetings with people who are looking to become clients and eventually become clients. And one of the things that they're really cagey about initially is how I view them, I think, and how that's going to affect the case. And so one of the things that happens as a result of that is people, at least initially, are reluctant to be honest with me about the facts of their case. One of the things that's absolutely true is that lawyers have a complete duty of confidentiality to their clients. What that means is the statements that you make to your lawyer are confidential and cannot be disclosed to third parties without your express permission. So when you're hiring a lawyer, do you tell them whether or not you're guilty? Well, first off, frankly, lawyers aren't going to ask you that question, especially criminal lawyers. One, because a lot of people don't know whether or not they're actually guilty of the crime. Crimes in Colorado and in every state have very specific definitions. And a lot of those things aren't necessarily things that you would think about when you're having your own internal dialogue about if you feel wrong for some act that you committed. And that's really the difference between a priest and a lawyer, right? A priest will ask you how you feel about a certain action that you took, and a lawyer wants to know whether or not the facts in your specific situation meet the elements of the statute, which is defined in the criminal code. So take, for example, something like first-degree assault. Well, first-degree assault in Colorado is a Class 3 felony. It's almost always charged as a crime of violence, which means that it carries a significant penalty if you're convicted, which is between 10 and 32 years in the Department of Corrections. All right, so what's the definition of first-degree assault? Well, it's an assault that causes somebody serious bodily injury. And one of the things that the DA has to prove in order to convict somebody of first-degree assault is that they intended to cause that person serious bodily injury, which is different from a lot of other charges that carry lesser mental state requirements, so where somebody can be convicted if they knowingly did something or recklessly did something or did something with a degree of negligence that our law doesn't allow. But for first-degree assault, because it carries that significant penalty alongside it, DA has to prove that somebody intended to cause somebody serious bodily injury. And so in a situation where, for example, you have a long night out and maybe that night involves some drinking or some use of mind-altering substances, if a person gets into a fight following that evening and as a result of that fight somebody has, for example, a broken arm or some significant injury, then that's actually a defense to first-degree assault, is that because of their level of intoxication, they did not intend to cause somebody serious bodily injury when they got into a fight with them. It was just a fight, and they were too intoxicated to know better. Well, that's a defense that's not going to be available for other types of assaults. And if you're charged with first-degree assault and, after the hangover wears off and you realize that that other person that you got in a fight with had some serious injuries, you might believe that you are genuinely guilty of that crime. But if you go and talk to a lawyer, they'll ask you about the things that led up to that crime. And during that conversation, you may realize that because you weren't of a conscious or at least rational state when that fight happened, that you didn't commit that crime. Now, that doesn't mean you didn't commit other crimes. I mean, there's still plenty of other things the DA can charge you with. But that one that carries the huge penalties associated with that kind of intentional crime isn't going to be a charging avenue available to the prosecution, or at least you may have a very, very good defense to that charge. So that's part of the reason that criminal defense attorneys don't ask clients whether or not they're guilty or not guilty of a crime, is because you may not know if that's the case or not. The other part is that criminal defense attorneys don't only represent people who are not guilty, right? We represent everybody. And part of that, and part of the reason we do that is because we're not only defending our individual client, but with every case that we take on, we're defending the Constitution, and in a very real sense. So, you have a right, if you're accused of a crime, to be presumed innocent of that charge until and unless the district attorney proves your guilt beyond a reasonable doubt. Well, this presumption of innocence that you have and this requirement of the DA to prove your guilt beyond a reasonable doubt, well, that only really applies if there's somebody on the other side asking the questions about the proof that the DA is presenting. I'll give you another example. Imagine that you're charged with the crime of driving under the influence, right? DUI. Is it enough for a police officer to come into court and tell a jury, well, yeah, he was drunk? Does that cut it? Is that sufficient? Well, I mean, if you don't have somebody on the other side asking those questions, it might be, right? There's plenty of people that have seen, I'm sure every police officer in the world has seen a drunk person from one time or another, and just about every citizen has as well, right? And we generally know what drunk people look like. So is it enough that somebody comes in with a badge and a gun and says, yep, they were drunk and I pulled them out of the front of a car? Well, if you don't have somebody else asking the other questions, then that might be. But think about the other things that can mimic intoxication by alcohol. Well, did the cop ask if the driver had any medical issues? Well, if somebody's diabetic and the diabetes isn't being properly treated, the symptoms of that insulin irregularity can mimic the symptoms of being intoxicated. So can being very, very tired can mimic a number of those symptoms. So can somebody with a speech impediment or a natural slur. All of those things add up, and if a police officer isn't doing a thorough investigation, they can miss those things that have an innocent explanation. And if you don't have a defense attorney on the other side asking, well, Mr. Officer, did you ask the medical questions? Do you know if he had a speech impediment? Did you ask him if he drank alcohol or if this was a result of some kind of prescription medication? If we're just assuming that, because somebody gets out of a car and stumbles and they're slurring their words, that they're drunk, that may be sufficient for some of the cases, but not for all of the cases. And at the end of the day, it's the DA's job to prove beyond a reasonable doubt your level of intoxication. So that's what attorneys do when they're defending a case. They're not only defending the individual, but they're breathing life into these constitutional requirements. In a criminal case, we never have somebody that's found innocent. We have somebody who can be found guilty or not guilty. But there's no finding of innocent under our law. And that's for a reason, right? When you plead not guilty and set your case for trial, what you're saying is you're not saying that you're innocent, although you may well be. What you're saying is you're telling the district attorney to prove that you're guilty, and you have an absolute right to do that. So it's a big difference between pleading not guilty and saying I'm innocent, I didn't do anything wrong here, or saying, look, under the laws and under the Constitution, you have to actually prove that, so bring forward the evidence. Here's another important part of it. Even if you are guilty, even if you're 100% guilty, there are certain protections in our criminal code that apply to prevent police and law enforcement from doing things that infringe on your constitutional rights. So, for example, we could probably go out and convict a lot of people in this country of a lot of crimes if we installed 24/7 video surveillance in their homes. But we won't do that. And that's because you have a Fourth Amendment right to be secure in the privacy of your own home. Now, when law enforcement steps out of their lane and when they invade on your constitutionally protected privileges as a member of this society, then there are protections that apply in the criminal code to discourage them from doing that kind of thing in individual cases and in cases in the future. It's called the exclusionary rule. What that does is it prohibits the district attorney and law enforcement from using evidence that was obtained as the result of a constitutional violation. So if police stop your car without a reason, if they search you without justification, if they charge you with a crime or have a judge sign off on an arrest affidavit without providing sufficient probable cause, well, those are all things that violate your rights, and a court, when reviewing the police officer's conduct, if it finds a constitutional violation, will suppress that evidence and sometimes even dismiss the case in its entirety. And that's not a loophole. That is a decision that our judges have made as a way, and really the only way, of protecting the citizens in this country from police overreach. That's the only thing that you can do to keep them from overstepping their authority, is to take away the one thing that they're trying to get from those constitutional violations, which is that evidence needed to convict somebody. So our law has decided that we're not going to let even a guilty person suffer the consequences of a constitutional violation. So say you come into your lawyer's office and you tell him that you're 100% guilty, and even after discussing the elements of the charges, you're still saying, hey, I'm 100% guilty. How does that affect the case? Well, it doesn't prevent us from offering you complete representation all the way through the case. But there is one thing that is going to affect, and that is our decision on whether or not to have you testify. Lawyers cannot put on perjured testimony. That's an ethical obligation that we have. So we will never reveal the statements that you've made to us admitting your guilt in the privacy of our own offices and in that confidential setting. But we also won't allow you to get on the stand and say that you didn't do the thing that you've told me in the privacy of my office that you did, because that's perjury. Now, we're not going to get up and scream and yell and throw our hands around, but what will happen is if you're getting up and you're going to offer perjured testimony, we can't prohibit you from getting on the stand, but we're just not going to ask you any questions. And so we're going to sit at our desk, and you can tell the judge and the jury exactly what you want to tell them, knowing that it's perjured, but those things never end up going well. So fortunately, you don't have to testify if you're guilty. The Constitution presumes you innocent, and your decision not to testify can never be used against you in the court of law. So the DA can't argue that because you didn't testify, you're guilty, and the jury's not allowed to presume that because you didn't testify that you had something to hide or you're guilty. So we still get to cross-examine the police officers about what they did and didn't do. We still get to bring up the inconsistencies in testimony from one witness to another, and we can still argue any constitutional violations in the case. So that's the reality of what happens when you tell your lawyer that you're guilty of a crime. It should never prevent you from having an open and honest discussion with your lawyer. That's really the only way that we can provide you with the best possible representation, is if we know more information than the other guy in the case. So don't ever think that that's going to hurt your defense. It's only going to make it better when both you and your lawyer are on the same page. My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado, and I want you to know your rights and know the law.